A very good evening to all my dear students. Welcome for today's class, the fourth session of Prospectus. Today we will be completing the chapter number 3, that is Prospectus and Allotment of Securities. Good evening, Pooja, Kuldeep, Amar, Gopal, all those who are present with us in the class. A very good evening to all of you. So I hope you have revised what we have done in the previous class and you're all geared up for private placement and allotment of securities, the last part of the chapters which is left. So today we'll be completing section 39, 40, 41 and 42, the 4 remaining sections. Before that, we'll be revising section 34, 35, 36, 37 that we have done in the previous class. And at the end, we'll be doing n number of questions, practical questions, so that you get the knowledge about how to attempt the paper also. And also your queries will be handled here in the class itself. So I hope you all are ready with your pens and papers and pencils, with your highlighters. Study material is open in front of you. And let's start with the chapter where we have left in the previous class. So we have already completed section 23 to 29 and we have revised it. After that, section 31, 32, 33 about all the shell prospectus, red herring prospectus, abridged prospectus were done. So let me have a quick recap and see how well my students are learning and revising. So the first question for the class is, I am a company ABC Private Limited and I want to issue a prospectus for my IPO. Can I issue a prospectus at the time of IPO? Mustafa says yes. Wow. Anubhav Malik says no. So Anubhav has heard the question. Dhyan se. Very good. Julie Kumari, very good. So it's a private limited company. Private limited can never go for initial public offer. It is not required to issue prospectus. It always has private placement. Why it has a private placement? Because it's a private company, a small limited company. Yes, now you're correct, Mustafa. Anil, you're also correct, not possible. So section 42 governs the rules and regulations. So today we'll be understanding what the section 42 tells us, how the private company is going to raise the money. And it has rules laid down in rule 14, which tells the procedure to be followed for raising the money for a private company. Is that clear? All right, let me see what others has answered. All right. Yes, good. Deepika, good evening. Deepika, Amar, all those who have joined now. Okay. After that, my question goes to the classes. What prospectus is required to be issued in which the number of shares and the price at which the shares are to be issued is missing? That kind of prospectus is known. It is known as excellent red herring prospectus, and it's a abridged prospectus. Anil, you're wrong. It's red herring prospectus. Most of you have given the correct answer. That's great. And what happened when the red herring prospectus is issued? It's a draft prospectus, and once the price has been finalized on the basis of market analysis, a price range is fixed. Say, for example, 20 to 45, the range the company has given to the outsiders, shareholders. And say, for example, they have picked up the rate, maximum people have fixed the rate to 22 or 25. So they have decided that 25 per share will be allotting. So now whatever is the total share capital, it will divide it with the price per share, that is 25, and number of shares will be calculated. And all these variations between the red herring prospectus and the final prospectus will be highlighted. And the final prospectus, red herring prospectus, will then become the final prospectus. When does it become? Upon the closing of the offer. As soon as the price is determined, number of shares are determined, now it becomes the final prospectus. So my next question is red herring prospectus a final prospectus? Yes or no? Absolutely correct. No, ma'am, it's not a final prospectus. Very good. Very good. Now, Anil earlier wrote abridged prospectus, to which I said it's wrong. So let me ask you, what is abridged prospectus then? Can anyone tell me? Can you raise your hands? End of offer of red hearing prospectus. Yes, Anubhav. When we end it, then the final prospectus is issued. Okay, Julie, what is abridged prospectus?
Abridged prospectus contains salient features of a memorandum prescribed by the Securities and Exchange Board of India.
Absolutely correct. So it has the salient features, it has the summary of the prospectus, how it has been issued, and what all summary. Main prospectus is for 400 to 500 pages. So it becomes difficult to read whole of the prospectus. So with every share application, a copy of abridged prospectus, a single sheet in which all the summary of the main prospectus is written and it is highlighted over there. Okay, and others also, those who have answered in the chat box, Geeta, Anubhav, everybody is correct. Deepika, Amar, Mustafa, all of you are correct. So the next question is, good, Savia Khan. Was there any term used as deemed prospectus? So I used this term in section 31. I used this term in section 25. I used this term in section 28. What is the meaning of deemed prospectus? When do we say it's deemed to be a prospectus? Under section 25, what is the meaning of deemed prospectus? Yes, Mr. Chavan, we're raising your hand. Would you like to explain? Ria, anybody would like to raise their hands and explain what is deemed prospectus under section 25? Not revised, children? Kuldeep. Adil Khan, Prerna, good answers. Shamli Sharma, let me see the students who are answering on the admin portal also. Mr. Santosh. All right. So section 25, any notice that invites to buy the securities. Okay, Adil Khan. So let's have a quick recap of section number 25. Section 25 tells you when the securities are being given to the outsiders, they are taking our securities and selling them in the market. So company has allotted its securities being offered for sale to the public. Company is not going directly. An issuing house has taken all those documents and have gone to the public. Then that allotment is considered to be an offer made to the public only if either of any condition is satisfied. So if the securities are offered within 6 months of allotment or the full consideration has not been received, then only this document that you have used under section 25 shall be considered as a prospectus. If my full consideration has been received and securities are offered in 9 months, will you call it a deemed prospectus? Yes or no? Very good. Then it is not known as deemed prospectus. Very good, Shamli, Anubhav, Kuldeep, all those who have given any document by which the offer is made to the public. Issued under intermediaries. Very good, Anil. That's correct. No is the correct answer for this one because then it shall not deemed to be a prospectus because we have already, if we have not met these conditions, then it shall not be deemed prospectus. And what is the meaning of deeming provision? Section 26, all the contents in section 34 and 35 will become applicable. Also, we did a case of Kunakulam Paper Mills Limited, where it was held by SEBI that if you are making a right issue to the existing members which exceeds 50, then also the document becomes a deemed prospectus. All right. What are the matters additionally to be stated in the deemed prospectus? So we said that the matters to be stated in the prospectus are under section 26, which are given. But three things additionally to be stated in the deemed prospectus. Consideration which have been received, the time and place where the underlying contract can be inspected, and the person who is making the offer, person who is named in the prospectus as directors of the company. Who is going to sign it? At least two directors if it's a company, and if it's a partners, then half of the partners. But my question to the class is, if it's a prospectus containing all the contents of section 26, and it's not a deemed prospectus, it's a prospectus, then who is supposed to sign the prospectus under section 26? This is the prospectus, which is the deemed prospectus to be signed under section 25. But my question is, who will sign the prospectus under section 26? Very good, Ria. All the directors, including the proposed directors. A solicitor who is representing on behalf of them. Excellent, excellent. So here it is written under section 26. The signing has to be done by all the directors and including proposed director. Duly authorized attorney can also sign in the representative capacity. And if I have not filed the signed copy of the prospectus with the registrar and I issue and allot the security, will it be considered as the valid allotment of securities? Will it be considered as the valid allotment of securities? Tell me. If I have allotted the securities without filing my prospectus, then it is a void allotment of securities. This is what we're going to understand today. How the irregular allotment of securities happen if any of the default is being made under section 23 or under section 26 or under section 39 or under section 40, then it shall deem to be a void. The contract becomes void. It has to be dated. Even if you have not dated the prospectus, then also it's not valid. So we were revising section 26, all the additional matters. You remember all these declaration supports. We have revised this. Experts bhi अच्छे से याद है, किसी को कोई doubt in the expert exceptions. When the prospectus is not required to be issued quickly. I have closed the sheet. Give me answers in the chat box. When the prospectus, the two exceptions in which prospectus is not required to be issued. Tell me. Okay, Mr. Chavan would like to answer. Yes, please.
A prospectus shall not be required to be issued where it has been issued to when the securities are issued to the existing members or debenture holders of the company, or such securities are uniform with the securities listed on the recognized stock exchange.
Which have already been issued, having uniform rights, which are already listed. Excellent, Chavan. Very good. Very good. So absolutely correct answer, and others also have answered it correctly in the chat box. Yes. And on the face of the prospectus, what we need to specify, all the list of the documents and statements that are attached with the prospectus, and you need to write down that the copy of the prospectus has been delivered and filed with the registrar. For how many days the prospectus is valid after filing it with ROC? 90 days. After this, you all remember these points. Section 27 mein koi bhi problem? Variations cannot be made. SR needs to be passed. Dissenting shareholders are given the exit offer. All these things we have also done in the questions. Section 28 also we have revised in the previous class. Today we'll understand the meaning of minimum subscription and minimum application value. This also we have revised. Section 29. Section 30 talks about the advertisement. We did a question also. Okay, let's do this question. Examine the validity of the allotment of the shares Board of Directors of Reckless Investment Limited have allotted the shares to the investors without issuing the prospectus with the concerned ROC. So if such a kind of question comes, I know you all know the answer, it's void. How you have to write it? The relevant provision says, according to section 23, a public company, while issuing the securities, can do only by issuing a prospectus. One of the content, section 26, says that all the matters included and disclosed requires the prospectus to be registered with the ROC before it is issued. Therefore, company has violated with the provisions and the allotment made is void. Company will have to refund the entire money received and will be punishable under section 26. Now, this conclusion is very important because where is this conclusion written in the study material? It is written under section 40, which today we will understand. So the company has violated the provisions. They have not filed it with the ROC. Allotment is void. And फिर क्या करना पड़ेगा अगर allotment void है? सारा का सारा पैसा shareholders का वापस कर दो. They will have to refund the entire money received and punishable under section 26. Can anyone remind me the penalty and punishment under section 26? What was the punishment or the penalty under section 26? Raise your hands. Very good, Anubhav Malik. Correct answer. Julie Kumari, good. Who else is writing the penalty? Only 2 students have answered so far. 35,000? Huh? In a doubt. Good, Adil Khan. Shamli, correct. 50,000. But Mrs. Prajapati, good, beta. 50,000 to maximum 3 lakhs is the penalty. Good, Geeta, fine, good. Correct. So this was the penalty under section 26. 50,000 to 3 lakh. In both the cases, it's same, whether it's a company or any officer in default knowingly issues the prospectus, 50,000 to 3 lakh rupees penalty be charged. After that, we have already done these questions. MCQs were all discussed with you. Shelf prospectus में किसी को कोई doubt? Shelf prospectus along with the information memorandum is equal to deemed prospectus. We are not issuing the prospectus again and again, so we use shelf prospectus. Red herring was also done. Abridged has also been revised. Then was the misstatement in prospectus. Who is going to tell me the meaning of misstatement? Misstatement क्या होता है? How did we learn this? False means untrue. Hide means suppress the material facts. Omit means not included. Any material information has been told false, not included, or suppressed, which is affecting the decision of the investors, then it is said to be a misstatement in prospectus. And if there is a misstatement, which section gets attracted? Section 34, and the person, directors, promoters, and every authorized person will be liable under 447. So section 34 talks about the criminal liability. Everybody who has authorized the issue of prospectus will be held liable, punishable under 447. But if I ask you, there was a director, Mr. A, who has authorized the issue of prospectus, which failed to disclose the name of the associate companies. They have omitted to include, or they have given a wrong name, false statement for the associate company. When they cannot be punishable under section 34, what kind of defense they can use? If they prove to the court that this information was immaterial, then they are not punishable, but this information is quite material. Or they had reasonable grounds to believe. They had relied on an illegal document. They were relying on the auditor's report. They themselves have no knowledge about including the name of associate company. They were only relying on whatever the auditor has finalized. So if the auditor is at mistake and they are very innocent, they do have no knowledge, then they can be protected under this act. And when does civil liability comes into picture? Section 34 हो सकता है, section 35 तभी होगा अगर section 34 है, if only there is a mistake. So civil liability means the person has suffered any damages. You have subscribed to the shares and now you have suffered damages. So every company director, promoter, expert, everybody who authorized the issue of prospectus shall be liable to pay compensation to the investors. And what are the three defenses where the directors can save themselves under Section 35? If they say that I have withdrawn my consent to act as a director, I was traveling and the prospectus was issued without my knowledge, I immediately gave a notice in the newspaper when I came. Or I have believed on the expert's consent. वहां ऑडिटर के ऊपर बिलीव कर रही हो, एक्सपर्ट के ऊपर बिलीव कर रहे हो, थोड़ा अपना भी दिमाग लगा लो. अगर नहीं लगाया तो ये बचाव के लिए, डिफेंस के लिए, प्रोटेक्शन के लिए आप यूज कर सकते. 447 we have done twice. I hope everybody remembers, and we did quite good revision also. So whenever there is any fraud in the company, 447 gets attracted. Peak versus goodness, remembered by all. If you're buying the shares in the primary market, then only you can file a case for the misstatement. If you have purchased from somebody else in the secondary market, then you cannot claim the damages. Only on the basis of prospectus IPO. All these questions were done, I believe. Then Section 36. What was Section 36? Who is going to explain me? I'm not going to revise with you. It's your revision. दो section रह गए revise करने. जल्दी से बता दो Section 36. Because today we are going to complete the syllabus and prospectus will be over. Only Chavan has raised his hand. Others have not understood Section 36. Yes? Don't you know Mr. Pavani, Miss Pavani, Julie Kumari, Ria, Manisha, Harsh, Anubhav? None of you know that answer. Pooja B. Why you're not raising your hands? Ms. Shilinga, Deepika, Insia. Who would like to explain this point? Okay, Mr. Krishna.
Any person who has either knowingly or recklessly makes any statement or promise or forecast which is false or misleading or deceptive, or deliberately conceals any material fact, then such person shall be liable to
No, but he does all these things. He does all these things to induce the other person. So word induce is very important in Section 36. You're using all these negative words just to encourage the other person to enter into an agreement for sale or purchase of securities. Yes, yes, continue.
Sorry, ma'am, I don't remember anything after that.
Okay. That's fine. Shamli, at least you tried, Mr. Chavan. Yes, Miss Shamli.
In this section, any person who knowingly and recklessly makes a contract and induce other person to come into an agreement in order to acquire, dispose, subscribe, and underwrite securities. Second point, the agreement was made in order to secure a profit from the yields of the securities. And third point, to obtain a credit facility from the any bank and financial institution.
Very good. Then what will happen? Section 36 will become applicable, but what is the liability? Then that person will be liable under
Section 447.
Yes, because it's a fraud when you're inducing you yourself, you're not buying the shares, you're encouraging the other person to buy the shares on the prospectus, which you believe is misleading.
Yes, ma'am.
All right. And what is Section 37? Any person who is affected under 34, 35, 36 will file a case against the company, either individually or group of persons or any association of persons can together file the case. And what was Section 38? चलो जल्दी सुनाओ Section 38 personation में क्या था? If you have used any fictitious name or group of multiplicate fictitious names you're using, or company is using a fictitious name and issuing securities, then under Section 38 also 447 will become liable. And there was a term known as disgorgement. What will government do? Government will take out all the funds from you, whatever the profits the company has earned by making these false statements. It has been taken out by the government. Is that clear to everyone? Let's start with Section 39. We have already started with it. Allotment of securities by the company. What is the meaning of allotment of securities? What is offer and what is acceptance? Who is going to tell me? What is the meaning of offer and what is the meaning? Now we are going to make a contract between the company and the shareholders. Yes, Anil, you raise your hand. Now we are going to make a contract. So who is a company, who is making an offer and who is giving acceptance? Yes.
Offer means invitation. We are inviting the person to buy our shares, and when that person makes a acceptance and buy that securities and enter into a contract, it makes a lot. It makes a contract. Sorry.
So absolutely wrong. So when I am giving the invitation, I'm issuing the prospectus. That is invitation to offer. कंपनी तो इनवाइट कर रही है, सुनो सुनो मैं प्रोस्पेक्टस लेकर आ रहा हूं, मुझे चाहिए शेयर होल्डर्स मेरी कंपनी के लिए. So I'm inviting, I'm announcing, I'm giving an advertisement. Then when the shareholders come and give you the offer, I am Mr. A shareholder, I want to buy your shares. B says I want to buy your shares. C says I want to buy your shares. They are inviting, they are giving the invitations. And once the company accept, that is the offer that they're giving to the company कि हम आपके shares खरीदना चाहते हैं. That means receiving the applications. Now I'm getting the applications from various shareholders. A कह रहा है मुझे दो, B कह रहा है मुझे shares दो, C कह रहा है मुझे दो, D कह रहा है मुझे दो. कंपनी कहती है ठीक है हम A, B, C को दे देंगे, D को नहीं देंगे. तो A, B, C की ऑफर हमने क्या कर ली? एक्सेप्ट कर ली. D की नहीं करी, रिजेक्ट कर दी. हमारी मर्जी, हमें देना है देंगे, नहीं देना. हमें आपने ऑफर दी, हमने एक्सेप्ट करी. जिन जिन की एक्सेप्ट करी, ऑफर प्लस एक्सेप्टेंस इज इक्वल टू व्हाट? Offer plus acceptance is a contract. This chapter, I love this chapter, the last part, because it takes you back in your initial CA foundation days. That is Indian Contract Act. Under section 35 also we went to Indian Contract Act for doing all the liabilities, damages. Section 72, 75 was there. Again, he is telling you the basics of invitation to offer. Remember, first chapter of Indian Contract Act, where you understand what is offer, proposal, and offer once accepted becomes a contract. However, the prospectus, advertisement, display of goods, that is an invitation to offer, which is different from the offer. Can we give acceptance on the invitation to offer? My question to the class. Can I make a contract by giving acceptance on the invitation to offer? Can a Mr. A shareholder says, I have accepted your offer because you issued the prospectus, so now it's a binding contract. Jaya Manoja says, no, not at all. You can only accept the offer, not the invitation to offer. So what do you make on the invitation to offer? Whenever there is an invitation to offer, on that you give an offer. And on the offer, you give an acceptance. And once the offer is accepted, it becomes a contract. Very good. So allotment means appropriation of unappropriated capital of the company. So मेरी कंपनी की जो भी unappropriated है, मतलब मैंने authorized share capital के बारे में सोचा हुआ. Now the time has come to issue this capital to the shareholders, and let us see how much they're going to subscribe to it. So I'm going to appropriate my capital of the company. I'm going to divide it. I'm going to allot the shares. That is the meaning of allotment of securities. But there are two mandatory conditions to be fulfilled. Then only the allotment is said to be valid. Otherwise, if these conditions are not fulfilled, the allotment is said to be void. Very, very important. लिख के रखो. If these two basic conditions are not satisfied, then it is said to be irregular allotment of securities. And such a contract would be void. A company can allot the shares to the public only when the minimum subscription has been received and the sum payable on the applications have been paid or received by check or any other instrument. Minimum application money not less than 5% of the nominal amount or any other amount specified by the SEBI should have been received. So what are the two main conditions? Minimum subscription. Public should have subscribed to minimum 90% of the shares should have been subscribed, means taken up by the public. and 5% of the nominal value should be received on the share application. Now, what is the meaning of subscribed and share application? Why don't let's go back to our class 11th, 12th share capital and debentures chapter. So when shares are allotted, how do we receive the money? First, share application money is received, remember? Then we receive share application, share allotment happens. First call is made, second call, remember? Forfeiture of shares, reissue, ऐसा ही होता था ना आपका accounts. So, अब ये जो share application money है, कितनी receive होनी चाहिए? अगर आपका issue price 100 rupees है, then at least 5% of 100 should have been received, means at least rupees 5 should have been received. Then only the shares can be allotted to this respective person. And what is the meaning of minimum subscription? So minimum subscription, children, is told by SEBI. SEBI laid down the rules and regulations for the minimum subscription. As of now, it says 90% of the shares should have been subscribed. Now, what is this meaning of this line? Should have been subscribed. So if company ABC Limited has 1 lakh shares as authorized share capital, so it has issued to the public 80,000 shares. Now, what is 90% of 80,000? 72,000 shares should have been subscribed. Then only the allotment of securities can take place. If the minimum 90% has not been subscribed and still you allot the securities, then it's not a good allotment. Then it's a void allotment. It's an irregular allotment of securities. So 90% of the minimum subscription should have been received and 5% of the nominal share price of the price of the share. 100 rupees price है तो उसका 5% receive हो जाना चाहिए. But in the book, we'll see there is a different provision for the listed companies. SEBI has given 25% of the nominal amount. So for those respected listed companies notified by SEBI, 25% is the amount. So whatever is written in the prospectus in accordance with the SEBI rules is something to be noted by the companies. So everybody understood. And third point kya tha? That the amount should be received other than by cash, means amount should have been received by check in the scheduled bank. So what is the meaning of scheduled bank? It is a list of banks given by Reserve Bank of India under second schedule of RBI Act. So Reserve Bank of India will tell which is the respective scheduled bank in which you shall be receiving that amount. And children, a separate bank account is maintained so that we can keep a record about how many people have subscribed and how many application money has been received, whether we have fulfilled the condition of 90% and 5% of the nominal value or not. And tomorrow, if we want to give back the money of the shareholders, we shall be paying in the same bank account from which the money has been taken. So how does it happen? If the minimum amount has not been subscribed and the sum payable on application is not received within 30 days. So what is the time period for fulfilling these three conditions? Within 30 days, we should receive the 90% of the subscription and the share application money, that is 5% of the nominal value. If this is not done in 30 days from the date of issue of prospectus, then within the next 15 days, the amount received from the applicants shall be returned. But if you have received and you have made the allotment of securities then you need to file the return of allotment under PAS 3 form. So PAS 3 form we are going to use for making the allotment of the securities. Any default, if the company and officers who make a default under section 39, they will be liable for a default of 1,000 per day or rupees 1 lakh, whichever is less. So company made a default in 40 days in issuing the securities. It had to issue the securities within a period of 30 days if you have received the amount. Securities were to be allotted. If you have not allotted and there is a default which continues for 40 days, then what will be the penalty? 40 into 1,000, that is 40,000 rupees or 1 lakh, whichever is less. But my dear students, if the default continues for 200 days, then what will be the penalty? If the default continues for 200 days, then what is going to be the penalty? Then 200 into 1,000, that is 2 lakh rupees. So where is this? So the maximum penalty, it cannot go beyond 1 lakh rupees. So if 200 days default, then also the maximum penalty will be 1 lakh rupees. Everybody has understood till here? Any doubts till here? So what is the condition? So there are two conditions for the allotment of securities. Minimum subscription should not be less than the prescribed amount. What is the prescribed amount? As stated in the prospectus, as per SEBI, it says it should be 90% of the amount. And the application money should be received in check, not cash. If you're receiving the money in cash and you're allotting securities, write down, it is irregular allotment of securities. If you are receiving the money in cash, if the company is receiving the share application money in cash, दिखना है ये सब अपने notes में, and allotting the securities, it is known as irregular allotment of securities. Okay, so the two conditions are minimum subscription 90% and minimum application money, that is 5%, should be received by check or any other negotiable instrument, but not cash. And the amount shall be received within how many days? Within 30 days of the date of prospectus. If no allotment is made within 15 days from the closure of issue, 15 दिन बीत गए और आपका amount नहीं आया and आपने allotment of securities नहीं करी है, then refund the amount of the shareholders. Refunded amount will go in the same bank account from where the money was received. And if the shareholder has not refunded, director has not refunded, then every director shall be jointly and severally liable for interest at the rate of 15% per annum. So what is the flow chart? Share application money received in check and not in cash. Minimum subscription received. Both conditions met. Allot the securities. Within 30 days of the close of issue. And if minimum subscription and minimum application not received, then company shall return or refund the money in next 15 days. If this amount is not received, then the company shall return and refund the money, return or refund the money in 15 days. If it fails to refund the money, then directors shall become पर्सनली एंड ज्वाइंटली लायबल, इसका मतलब क्या होता है पर्सनली एंड ज्वाइंटली लायबल? मींस कंपनी के साथ जो लायबिलिटी है वो भी है हमारी, अब हमारे पर्सनल एसेट्स आर आल्सो लायबल एंड द इंटरेस्ट एट द रेट ऑफ 15% per annum will also be charged on them. If the minimum subscription has not been received, both the conditions are met, then allot the securities in 30 days. Amount should have been received in 30 days, allot the securities. If it has not been received, then company should return or refund the money in 15 days. And the money refunded shall go in the same bank account from where it was received. All right. From where it, and if it fails to refund the money, then the directors become jointly and severally liable, means unki personal liability bhi ho jayegi, and it is at the rate of 15% per annum. So this is the chart that you all have to learn. So allotment of securities, minimum amount subscribed and the application money has been paid and received by the company, not less than 5% or other amount specified by SEBI. This amount received should not be in the cash. Minimum amount not subscribed and the application not received within 30 days or whatever time period mentioned in the prospectus, then the amount shall be returned within 15 days from the closure of the issue. जैसे issue close हुआ 15 days में return. But where the allotment is made, company will allot the securities and return of allotment within 30 days shall be filed with the registry. So 30 days में पैसा आना चाहिए, नहीं आया तो 15 days में return. And अगर allot कर दिए securities तो PAS3 फॉर्म है and return of allotment 30 days में registrar के साथ फाइल करनी है. सारी dates important है, ये वाली dates हम छोड़ नहीं सकते. 30 days, 15 days, 30 days, तीनों डेट याद करनी है. एंड इंटरेस्ट क्या है 15% पर annum. इसी पे क्वेश्चंस आने हैं प्रोस्पेक्टस में से. फर्स्ट टाइम कर रहे हैं, थोड़ा टफ लगेगा, पर बार बार सुनने से, क्वेश्चन प्रैक्टिस करने से ये स्टार्ट फाइल की रीजन. So within 30 days, the return of allotment shall be filed with the registrar. A return of allotment shall be filed in 30 days from the date of allotment. So what all will be included, that we'll see from the study material. And if default is made under section 39, then what will be the penalty? We just did 1,000 for each date continuing default, maximum up to 1 lakh rupees. So can we increase the penalty of section 39 from more than 1 lakh rupees? 1 lakh से ज़्यादा हो सकती है. Maximum कितनी है? 1. Very. So please read this question. I give you 2 minutes to answer this question in the chat box. I'm just getting some water. Please write in the chat box this answer. Very good. Everybody has answered it correctly. That's wonderful. So what will be the minimum subscription? 90% no allotment shall be made if the minimum subscription has not been received. The amount stated in the prospectus as the minimum amount and the sum payable for such amount has been paid. Application money should not be less than 5% of the nominal amount or such amount as SEBI may prescribe. Now, what is the interesting theory behind this such amount as the SEBI may prescribe? That I'm going to show you from the study. All right. So children, such a kind of question is such a, icing on the cake, straightforward question. Minimum subscription kitna hai, public application money kitna hai, and kyun restriction hai? Because if you don't follow, if the stated amount is not received within 30 days, then the company is required to refund the application money. And if it makes any default, penalty of 1,000 to 1 lakh will be charged. Section 40 subsection 3 says all the money received in this money for subscription shall be kept in a separate bank account with a scheduled bank. ये कहाँ लिखा है? सेक्शन 40 में लिखा है. मैं अभी आपको बताऊंगी इसके बारे में. Okay, this will be explained to you. Kuldeep, Savi, Ria, Adil, everybody has given the correct answer. 90% and 5%. हाँ, पूरा लिख कर आना है आदिल पेपर में. Okay. Excellent, excellent, Chavan. Everybody has beautifully written the answers. I'll show you the same from the module also. We have done all these questions of 447 also. Keep revising them. So this is what it says, section 39. Meaning of allotment. Offer of the shares on the application made by the company is accepted. It is allotment. Once the offer is made, we accept it. Allotment of securities is the contract. Can I accept without the offer? No. So allotment is not less than the acceptance by the company of the offer to take the shares. It is appropriating the previously unappropriated money. अब ये सबसे interesting है. When forfeited shares are issued, it is not the allotment. Can anyone tell me what is the meaning of forfeited shares? Very important. Forfeited shares कौन से थे? Remember, जिन पे पैसा नहीं आया है, तो कंपनी आपके shares forfeit कर देती है. Yes, Anil.
Ma'am, if the shareholder fails to pay any of call money, then company will automatically forfeit
The
the
shares.
shares.
Very good. Very good. Yes, Vedant. And what is reissue? Yes, explain forfeit first.
Forfeiture shares are the shares in which the people of the shareholders are not able to pay the shares application.
Absolutely, absolutely, absolutely.
Yes,
Then
the company reissue the forfeited shares.
Yes, Vaishnavi.
When company reissues the forfeited shares, which means that if a shareholder fails to pay any call money, they forfeit the shares. And
Yes, very good. Yes, I have understood you, Vaishnavi. Vaishnavi and all those Anil and Vedant, very well tried. So forfeited of shares, I could not pay the money. Now I have paid the money. Company has reissued the shares to me at another price. So here it is not allotment of securities. हम तो already member थे ना, shareholders थे who have been having this money. Now the allotment happens at the time of IPO. Here we are talking about the IPO allotment of securities. So valid allotment has to comply with the requirements of the Act and principles of Indian Contract Act. Here, when the forfeited shares are issued, it is not the allotment of securities. You are just giving them the shares back. Allotment means where the section 39 is allotment. Section 39 will tell you about the allotment when it is a public offer. ये तो आपके shareholders को आपने वापस reissue कर दी. जब पब्लिक में ऑफर करते हैं वो होता है अलॉटमेंट ऑफ सिक्योरिटीज। समझ गए? फर्स्ट रिक्वायरमेंट इज मिनिमम सब्सक्रिप्शन। शेयर्स आर ऑफर्ड, मिनिमम अमाउंट ऑफ सब्सक्रिप्शन हैज टू बी स्टेटेड इन द प्रोस्पेक्टस। हम जो कर रहे हैं 90% वो सेबी के अकॉर्डिंग। ये क्या कहता है? कितनी प्रोस्पेक्टस में मिनिमम सब्सक्रिप्शन लिखी है वो आई होनी चाहिए। मैंने लिखा 80% तो 80%। हरलीन मैम ने अपने प्रोस्पेक्टस में HK लिमिटेड में लिखा 70% should have been subscribed, then 70%. Shares will be offered only when the minimum subscription which is stated in the prospectus has been achieved. So this is a positive sense. Negative sense, no shares will be allotted until the minimum subscription has been subscribed. समझ गए? जब तक नहीं करेंगे तब तक नहीं शेयर्स देंगे। Sum payable on the application so stated has been received by the company in the form of check or any other instrument. कैश में लेंगे तो गलत। अब वो कहते हैं सेबी ने कहा है कि मिनिमम सब्सक्रिप्शन शुड बी 90% ऑफ द एंटायर। Any means by which the money can be remitted may be used, but remittance made and cleared actual cash received an application if not accompanied by such payment will not constitute the valid offer. Application money अगर कैश में आ रही है फिर वो वैलिड ऑफर नहीं है, कैश में नहीं आनी चाहिए। क्यों नहीं आनी चाहिए कैश में? रिकॉर्ड मेंटेन नहीं होगा ना। सेपरेट बैंक अकाउंट में हमें तो पैसा रखना है, देखना है कितना शेयर एप्लीकेशन मनी आया है, कितना सब्सक्राइब हुआ। दैट्स व्हाई दे वांट मी टू डू इट इन द फॉर्म ऑफ चेक। अब आता है यहाँ पे आपने लिखना है मिनिमम सब्सक्रिप्शन। इसकी हेडिंग है मिनिमम सब्सक्रिप्शन, पॉइंट नंबर 1। Point number 2, please keep marking down and keep colorfully decorating your study material the way I'm telling you. Point number 2, quantum of amount, share application money की बात करें, minimum application money. Application money should not be less than 5% of the nominal amount or the amount specified by SEBI. SEBI बताएगा। अब SEBI ने क्या बताया? Minimum sum payable on application for specified security should not be less than 25% of the issue. For offer of sale, full issue price. Okay, ये बताती हूँ, इसको बाद में बताती हूँ। कहता है सिक्योरिटीज एंड एक्सचेंज बोर्ड ऑफ इंडिया 29 पॉइंट में कुछ दिया हुआ है, पहले पढ़ ले 29 क्या है। वेरी नाइस, वेरी नाइस। SEBI are not part of syllabus at intermediate level. It is not necessary to build the understanding. SEBI is not part of your syllabus. Don't need to build your। कहता है उसमें मत घुसना, हमने आपको बता दिया है। स्टडी करिए सिक्योरिटीज एक्सचेंज बोर्ड ऑफ इंडिया में, क्योंकि एक्ट में लिखा है तो बताना तो पड़ेगा। नहीं तो आप बेयर एक्ट खोलोगे तो आप बोलोगे मैम 25% लिखा था, हमें तो बताया ही नहीं। सो बताएंगे बट डीप नहीं जाना। डीप किस में जाना है? एज स्टेटेड इन द प्रोस्पेक्टस सेबी 90% है। किस में जाना है? सबसेक्शन 2, 5% ऑफ द नॉमिनल अमाउंट और एज परसेंटेज स्पेसिफाइड बाय सेबी। सेबी ने कितना भी स्पेसिफाई करा है? 25% ऑफ द इशू। क्यों करा है, कैसे करता है वो नहीं सोच। अब ये लाइन इंपॉर्टेंट है, कोई मुझे बताएगा ये ऑफर फॉर सेल क्या होता था? OFS तो नहीं होता था? हाँ जी मैम, बिल्कुल OFS था, सेक्शन 28 में पढ़ा है हमने। फुल इश्यू प्राइस शैल बी पेबल एट द टाइम ऑफ एप्लीकेशन। ये क्यों कह रहे हैं फुल इश्यू प्राइस? ये कह रहे हैं 100 रुपीज का शेयर है तो 100 रुपीज पे करो। ये कोई मतलब नहीं 5% पे करो, 25%। क्यों कह रहा है? क्यों कहते हैं? कौन बताए? इंटेलिजेंट स्टूडेंट ऑफ माई क्लास हु कैन टेल मी दिस, मोस्ट इंटेलिजेंट। OFS में मैम एक्सेप्शंस थी। वेरी गुड साविया खान, एक्सीलेंट। क्योंकि मैम वहां पे तो एक्सेप्शन थी। आपने बोला था मिनिमम एप्लीकेशन नॉट एप्लीकेबल, मिनिमम सब्सक्रिप्शन नॉट एप्लीकेबल। सो भाई फुल प्राइस दो, इसमें थोड़ी ना सेक्शन 39 एप्लीकेबल है। Excellent, excellent. All of you have answered it correctly. I'm super proud of all my students that they can recall. Very nice. Very good. I'm seeing your answers. Prajapati, Shamli, very good. Prerna, Deepika, good. Pooja B, Geeta, Abhinav Mishra, great. So remember, children. Yes, Anubhav Mishra, it is applicable to all securities. So वर्ब is पे because यहाँ पे लिख लो साइड पे because in under section 28 exception is minimum subscription and application is not applicable. If listed company offer the shares with a nominal value of 10, then the application money should be 2.5. If the nominal value is 100, then it should be 25. क्यों? क्योंकि listed company है सेबी में आती है तो 25% of the nominal amount ले ले. अभी आती है इंपॉर्टेंट बातें. थर्ड पॉइंट सबसेक्शन है, हमने सबसेक्शन तो याद नहीं करने, हम तो पॉइंट्स बना रहे हैं. थर्ड पॉइंट, इफ द अमाउंट इज नॉट रिसीव्ड विद इन 30 days, फिर क्या करना है? अमाउंट रिटर्न कर देना. Refund will be made within 15 days from the close of the issue. 30 days from the issue of prospectus. Prospectus issue करा मैंने 1 October 23 को, तो 30th October 23 तक मुझे पैसा आ जाना चाहिए. क्लोजर ऑफ द इशू हो गया 30th अक्टूबर, अगले 15 नहीं आया तो अगले 15 दिनों में मुझे पैसा रिटर्न कर देना चाहिए. अगर मैंने रिफंड नहीं करा, फोर्थ पॉइंट था रिफंड करना है 15 डेज. फिफ्थ पॉइंट कहते हैं अगर मैंने 15 दिन में रिफंड नहीं करा, मैंने 18 दिन में रिफंड करा, तो सारे डायरेक्टर्स एंड अदर ऑफिसर्स विल बी जॉइंटली एंड सेवरली लायबल टू पे द इंटरेस्ट एट द रेट ऑफ 15% पर annum. 3 days का मैंने डिफॉल्ट करा, 3 days के लिए 15% पर annum का मुझे इंटरेस्ट लगा देना डायरेक्टर्स को एंड जॉइंटली एंड सेवरली लायबल. पॉइंट नंबर 6, अगर मैंने रिटर्न एप्लीकेशन रिफंड करनी है तो इट शैल बी केप्ट इन अ सेपरेट बैंक अकाउंट फ्रॉम विच द सब्सक्रिप्शन वाज रिमिटेड. सेक्शन 40 में हम पढ़ेंगे रिटर्न ऑफ एप्लीकेशन मनी इन केस द अलॉटमेंट इज नॉट डन. सो अभी दिमाग नहीं लगाना, ये पॉइंट सेक्शन 40 में. आई विल टीच यू इन सेक्शन 40. डोंट डिस्कस दिस राइट. रिटर्न ऑफ अलॉटमेंट कौन सी फॉर्म में करनी है? मैंने बताया था अभी, PAS 3 में रिटर्न फाइल करनी है, रिटर्न ऑफ अलॉटमेंट. एंड कितने दिन में फाइल करनी है? 30 डेज में फाइल करनी है. अंडरलाइन कर लो. अब ये पेपर में क्वेश्चन आएगा रिटर्न ऑफ अलॉटमेंट में क्या क्या कंटेंट्स लिखने हैं. So return of allotment PAS 3 में होनी चाहिए. List of the following particulars shall be included. Name of the allottees, what is their name, what is their address, what is their occupation, and number of securities allotted. कितनी हमने securities उनको allot कर. Is that clear? So let's have a quick recap. यहाँ तक आगे कराऊंगी. Section 39. Minimum subscription in check other than cash, in check or other instruments, allot securities. If allotted the securities, if received within 30 days, allot the securities. Minimum subscription and minimum application money, which is 5% of the nominal value or the amount stated in the securities. दोनों conditions and check वाली condition अगर met होती है, within 30 days होती है, allot the securities. अलॉट करी सिक्योरिटीज तो PAS 3 रिटर्न ऑफ अलॉटमेंट 30 डेज में रजिस्ट्रार के साथ फाइल. 30 डेज 30 डेज. क्लियर? नहीं हुई अलॉट, अच्छा फिर अगर रिटर्न अलॉटमेंट करिए तो उसमें क्या क्या लिखना है? नेम ऑफ अलॉटीज, एड्रेस, ऑक्यूपेशन एंड नंबर ऑफ सिक्योरिटीज टेकन. क्लियर हो गए ये पॉइंट्स? 6 पॉइंट्स. अगर 30 डेज में रिसीव नहीं हुआ तो रिफंड कर दो. कितने दिनों में? 15 डेज में. 15 डेज में रिफंड नहीं करा, डिफॉल्ट करी, तो 15 के साथ मैच होता है 15% पर एनम इंटरेस्ट चार्ज हो जाएगा एंड डायरेक्टर्स एंड अदर ऑफिसर्स विल बी जॉइंटली एंड सेवरली लायबल. इजी है? लेट्स टेक अ स्मॉल ब्रेक हियर एंड देन विल कंटिन्यू. अनुपम मलिक नहीं, हाँ जी सर, मनीष सर, वी टेकिंग अ ब्रेक. hope section 39 is now absolutely clear to anyone. Nobody is having any doubts. Let's move ahead with section 40. So we have done one question also related to section 39. So yes, Anubhav, you wanted to ask something. Yes, Shai.
Good evening, ma'am.
Good evening.
मैम मतलब बुक में एग्जांपल दिया है एक लिस्टेड कंपनी आप जो लास्ट में करवाए 2.5
Okay. I'll just take out the example. Which beta?
मैम 3.37
3.37. Okay.
मैम इसमें जो दिया है इसमें मैम दिया है कि लिस्टेड कंपनी ऑफर्स द शेयर मैम ये अगर लिस्टेड कंपनी नहीं होता तो अनलिस्टेड कंपनी होता तो उसमें हम कौन सा परसेंटेज मिलता है 5%?
Okay, I will explain you. Mute yourself. In this example you're talking, right? So here it says the minimum application should not be less than 5% of the nominal amount or such other amount as may be specified by SEBI. वो कहते हैं या तो 5% या जो सेबी बोलेगा. अब सेबी ने बोल दिया 25% of the issue price. So which amount has to be taken? 25% of the issue. What is law telling you? Subsection 2 tells you this is what we have to learn and remember. 5% of the nominal amount or such percentage as may be specified by SEBI. You can give a line downstairs that as per SEBI, minimum amount is 25% of the issue price. So if here listed company is offering the shares of 10 rupees, the application money should be at least 25% of 10. That is 2.5. If it is 100, then 25% of 100 is 25. क्यों ले रहा है 25? क्योंकि कह रहे हैं current rate 25% of the issue price. Learn कैसे करना है? Learn ऐसे ही करना है. ये दोनों पॉइंट्स लिखकर ब्रैकेट में नीचे as per SEBI 25% of the issue. Got it, Anubhav? Is that clear? All right. Thank you. I'm glad it's clear to you. Let's complete the points here first. List of allottees we have done. Additional attachments to be going with the PAS3 form if the consideration other than cash is issued. So we told you that the shares will be issued. Other than cash is the amount that you will be receiving. That is by check. Now, I have allotted you the securities, but the shares are issued for consideration other than cash. Means, हम आपसे पैसे नहीं ले रहे हैं, हम उसके बदले में कुछ और ले रहे हैं. For example, there is a company ABC Limited which allotted the securities to a dealer, Mr. A, who is into construction business. And Mr. A said that I will be making residential flats for you. So here the consideration being paid for the securities is consideration in kind. So can we pay the consideration other than cash? Can we pay in kind and get the securities? The answer is yes. So here if you have paid in kind, then a copy of the contract to which the securities have been allotted, then all these copies of the contract of flats. And if it is relating to any property or asset, then for a contract for the services or other consideration. मतलब इससे related जो भी आपका contract बना है कि आपने securities allot करी हैं, आपने घर खरीदा है या assets लिए हैं, उसका contract आपको return of allotment PS3 के साथ देना पड़ेगा. Basically saying inform registrar about anything. कुछ भी आप कर रहे हो अपनी मर्जी से नहीं करना. आपने अदर देन कैश लिया, बच्चा अदर देन कैश क्या होता है? इन काइंड आपने लिया सर्विसेज, तो कॉन्ट्रैक्ट की कॉपी दे देना जिसमें सिक्योरिटीज अलॉट हुई हैं. एंड सेल इफ प्रॉपर्टी इज एसेट इज इन्वॉल्व, कॉन्ट्रैक्ट ऑफ द सर्विसेज और अदर कंसिडरेशन, व्हाटएवर कॉन्ट्रैक्ट हैज बीन. एंड वेयर द कॉन्ट्रैक्ट इज नॉट इन राइटिंग, देन प्लीज गिव particulars of the contract stamped with stamp duty. अगर आपने घर लिया होगा तो कोई रजिस्ट्री के कागज होंगे जो कि स्टैम्प ड्यूटी लगी होगी, वो सब दे देना. नहीं तो रजिस्टर वैल्यूअर से रिपोर्ट लेकर दे देना कि क्या कंसिडरेशन. बट PAS3 के साथ ये पॉइंट नंबर 1, 2, स्टैम्प ड्यूटी वाला पॉइंट एंड रजिस्टर्ड वैल्यू 4, ये बताना जरूरी. क्लियर? If the shares have been issued according to clause C of subsection 1 of section 62. Now here it is taking you to share capital and debentures. कहता है अगर राइट्स इशू करें आपने, ESOPs करें of a company other than listed company whose equity shares and convertible preference shares are listed, then please give the valuation report of the registered value. तो उसमें भी रजिस्टर्ड वैल्यू की रिपोर्ट देनी जरूरी. Is that clear to everyone? Ma'am, what is section 62? Share capital and debentures coming up soon. There we will learn what is section 62. If any default is made, 1,000 rupees up till 1 lakh, whichever is this. Let's do this illustration. After receiving 80% of the minimum subscription, Raksha detectives, before finalizing the allotment, withdrew 50% of the said amount from the bank for purchasing certain assets. It then started allotting the securities to the subscribers. Rashmi, one of the subscribers, was allotted 1,000 shares. She refused to accept the allotment, saying that the allotment is violative of the Companies Act provisions. अब पहली बात, मुझे सब लोग ये आंसर करेंगे, क्या 80% ऑफ द मिनिमम सब्सक्रिप्शन प्रोस्पेक्टस में स्टेट की जा सकती है या नहीं? इलास्ट्रेशन में लिखा हुआ है 80% minimum subscription was, yes, it can be done. Very good. Mr. Chavan, I told you 90% of the minimum subscription is as per SEBI. अगर मेरे प्रोस्पेक्टस में कुछ नहीं लिखा, साइलेंट है, तो 90% SEBI वाला रूल अप्लाई कर देना. But what is law saying subsection 1? As stated in the prospectus. ठीक है, मुझे पता था यहाँ पे कंफ्यूज हो गए तुम लोग, बट शामली, केविन, प्रजापति सबने ठीक आंसर दिया है. गुड. It can be stated in the prospectus. So 80% amount was stated in the prospectus. Since minimum amount has not been received in full, there has been a contravention. Allotment is in contravention because it prohibits the company from allotting until it has received the minimum. अब यहाँ क्या हुआ? 50% of the amount उन्होंने reuse कर लिया. They are using this amount. Before finalizing the allotment, they have withdrawn the 50% of amount. You cannot withdraw the amount unless you have allotted the securities in complete. Okay. So here, it prohibits the company from making until it has received the amount minimum subscription. Such company is required to refund the application money, that is 80% of the amount, to the applicants. Therefore, she has the right to refuse because the allotment made was illegally made by the company. 39 subsection 3 ये लिखा हुआ है आपका. 39 subsection 3 के according you need to return the application money if the minimum amount has not been subscribed and the sum is not received or any other period given by SEBI, then amount received shall be refunded. At least the amount which is stated has been subscribed. So shares will not be allotted if the amount stated has not been subscribed. As per SEBI rules, minimum subscription 90% of the issue. Okay. But whatever is stated in the prospectus, that can be followed. Okay. Now let's start with section 40. Everybody's clear till here? Section 40 is very, very simple as well as very, very interesting. Section 40 tries to tell you that before making any public offer, you should first go and apply yourself to the recognized stock exchange. You have to apply to the recognized stock exchange. So which are the two recognized stock exchange? NSE, National Stock Exchange, and BSE, that is Bombay Stock Exchange. So before issuing the securities, I need to apply to any of these recognized stock exchange and take their permission that I am going to trade my securities on your stock exchange. So first point of section 40 is that you need to take a permission from any of the recognized. If you have taken the permission from NSE, you can do the trading on NSE. If you have taken the permission from BSE, then you need to do the trading on BSE. Very good, Shravan. That's absolutely correct. Include the names of stock exchange which the securities shall be dealt must be stated in the prospectus. So I am a company ABC Limited and I have taken the permission from Bombay Stock Exchange. So in my prospectus, I will write the name of Bombay Stock Exchange. My securities shall be dealt and traded at this particular stock exchange. फर्स्ट 2 पॉइंट्स है क्लियर. पहले तो परमिशन लेनी है. जो भी आपको परमिशन देगा, एप्लीकेशन कैन बी मेड टू मोर रिकॉग्नाइज्ड स्टॉक एक्सचेंज आल्सो. And once you have taken the permission, then include the permission of the name of the exchange from where you have taken the permission. Whatever application money that you have received shall be kept in a separate bank account in a scheduled bank. ये था सेक्शन 40 सब सेक्शन 3 का मोस्ट इंपॉर्टेंट पॉइंट, दैट जो भी पैसा आया है ना उसे सेपरेट शेड्यूल्ड बैंक में रखना है. शेड्यूल्ड बैंक क्या होता है? रिजर्व बैंक ऑफ इंडिया लिस्ट ऑफ शेड्यूल्ड बैंक्स निकालता है. एक्सिस बैंक इज आल्सो वन ऑफ देम. सो व्हाटएवर लिस्ट इज गिवन बाय द रिजर्व बैंक ऑफ इंडिया, इन दोस पर्टिकुलर शेड्यूल्ड बैंक आप पैसा रखेंगे जो भी एप्लीकेशन मनी आई. एंड उसे यूज नहीं करना. इट शैल नॉट बी यूटिलाइज्ड फॉर any purpose other than adjustment of securities or return of refund of money. कहता है मेरे को जो भी सेक्शन 40 सब सेक्शन 3 दो बातें कह रहा है आपसे. नंबर 1 क्या कह रहा है बेटा? कि जो भी एप्लीकेशन मनी आई है उसे सेपरेट बैंक अकाउंट में रखेंगे. एंड जो भी पैसा आया है उसे सिर्फ 2 चीजों के लिए यूज करना है. One for the allotment of securities and another is repayment within the time specified by SEBI if company is not able to allot the securities. So what is happening? Section 40 is a very, very simple section. First point, it says permission from BSE और NSE ले लेना. प्रोस्पेक्टस में लिख देना BSE है या NSE जिससे भी आपने परमिशन ली. थर्ड पॉइंट, एप्लीकेशन मनी जो आएगी उसे सेपरेट बैंक अकाउंट में रखना है एंड उसे 2 ही चीजों के लिए यूज करना. क्या है वो 2 चीजें? allotment of securities and refund of money in 15 days if securities are not allotted. अगर आपने allot नहीं करा तो वो क्या कर रहा था? वो परचेज ऑफ एसेट कर रहा था उस इलस्ट्रेशन में. ऐसे अलाउड ही नहीं है, आप कर ही नहीं सकते. यू कैन नॉट यूज द एप्लीकेशन मनी फॉर एनी अदर पर्पस. तभी मैंने कहा था सेक्शन 40 सब सेक्शन 3 वहां एप्लीकेबल. यू हैव टू यूज द एप्लीकेशन मनी इन सेपरेट बैंक अकाउंट रखकर सिर्फ अलॉटमेंट ऑफ सिक्योरिटीज और रिफंड ऑफ मनी इन 15 डेज के लिए ही आप यूज कर सकते. इसके अलावा आप वो पैसा कहीं और इस्तेमाल नहीं कर सकते. Any condition purporting to require and bind the applicants for securities to waive the compliance is not valid. कहता है आप इन कंडीशंस को वेव नहीं कर सकते कि मिनिमम सब्सक्रिप्शन नहीं आया तो भी चलता है, मिनिमम एप्लीकेशन नहीं आया तो भी चलता है. आप ऐसा कुछ भी करेंगे तो वो void मान लिया जाएगा. वेव नहीं कर सकते means you cannot give it up, you cannot remove it, you cannot delete it. कोई भी ऐसी कंडीशन आप कंपनीज एक्ट में लेकर इन कंडीशंस को वेव ऑफ नहीं कर सकते। अगर आप डिफॉल्ट करते हैं, मींस आपने प्रोस्पेक्टस इशू करे बिना ही सिक्योरिटीज अलॉट कर दी, आपने मिनिमम सब्सक्रिप्शन आए बिना ही अलॉट कर दी, तो मिनिमम 5 लाख से 50 लाख रुपीज कंपनी को फाइन है, एंड डिफॉल्टिंग ऑफिसर को सेम सेक्शन 26 वाला फाइन है, 50,000 टू 3 लाख। बट ये फाइन इंपॉर्टेंट क्यों है? क्योंकि यहाँ पे कंपनी को जो फाइन है वो अप टिल 50 लाख रुपीज है, 5 लाख से 50 लाख रुपीज। 447 में याद है ना, जैसे फाइन था लेस देन अमाउंट ऑफ फ्रॉड था तो 50 लाख तक फ्रॉड जाता है, फाइन जाता है। यहाँ पे 5 लाख से लेकर 50 लाख। A company needs to pay commission, but commission से पहले ये सारा याद हो गया। 4 पॉइंट ऑफ सेक्शन 40 सब सेक्शन 3, एप्लीकेशन मनी सेपरेट बैंक अकाउंट में जाएगा, सिर्फ अलॉटमेंट ऑफ सिक्योरिटीज एंड फंड ऑफ मनी के लिए यूटिलाइज करेंगे। कोई भी कंडीशन अगर वेव करते हैं तो अलॉटमेंट विल बी सेट टू बी वॉइड। एनी डिफॉल्ट 5 lakh to 50 lakh and 3 lakh 50,000 to 3 lakh fine will be charged. Let's do this question because today we have n number of questions and we have to complete section 41 and 42 also. A Limited issued 1 lakh equity shares of ₹100 each at par to the public by issuing the prospectus. Prospectus, just read it. Just take 1 minute and read it. So it says 1 lakh equity shares at par for the issue of prospectus. Minimum subscription amount is 15 lakh rupees to be received on application of shares, and share application money shall be payable ₹20 per share. Share application money, or remember, application, allotment, first call. So share application money पे 20 per share आना चाहिए. Prospectus reveals that A Limited has applied for listing of shares in 3 recognized stock exchange, out of which 1 application has been rejected. The issue was fully subscribed and A Limited received ₹20 lakhs on share application. It then proceeded for the allotment of securities. Tell us the 3 disclosures in the above case study which are the deciding factors for the allotment and if there is any violation. Now, before we proceed to the answer, let me show you one very important line. Every company will make application to 1 or more recognized stock exchange and obtain the permission for the securities to be dealt with its stock exchange. अगर आपने किसी भी स्टॉक एक्सचेंज पे अप्लाई करा है तो आपको उस स्टॉक एक्सचेंज से परमिशन आनी चाहिए. Public offer के time company will make the application to the stock exchange and obtain the permission. Prospectus will tell the name of the stock exchange on which the securities are to be dealt. Amount will be used only for adjustment of allotment or repayment of the money. Section 40 subsection 3 along with rule 11 tells you return of application money if the allotment is not done. Conditions related to 11 has been discussed before in the chapter, means we have 15 days discussion. But if you try to waive the compliance, it will be void, and default we have already done the fine. Is that clear? I just wanted to show you that all the points of section 40. Oh my God. Okay, Harsh Mishra, that's not a problem, beta, but you can try it out. You must give it yourself a try. Even if you have any doubt, then also you can raise a hand. You can try speaking it out. Okay? Okay, not a problem. Thank you so much, Harsh Mishra. I'm glad that you like the way I teach. So that's great. Okay, now let's see the answer. Everybody understood the question? So one of the permission has been rejected. This one, I don't expect you to raise the hands because this is a little complicated. I have to explain you this one. So how we have to write the answer? Relevant provisions of the case. First of all, the disclosures, which are the deciding factors, are laid down in section 39. Allotment will be done only if the amount stated in the prospectus as minimum amount has been received and the minimum application money has been received in the form of check, which should not be less than 5% of the amount of securities or as may be specified by SEBI. जो भी law में लिखा हो. Yes, Mrs. Mehak. First, let me explain, children, then I'll give you a chance to raise your hands. Relevant provision clear हो गया? Up given case and analysis, A Limited has issued the shares by issuing the prospectus with minimum subscription and the sum payable, and the amount received on the share application is more than 5%. Is that correct? More than 5% of the nominal amount we have received. A Limited has applied for 3 stock exchange. 1 application has been rejected. In compliance to section 23, nothing about the matters included in prospectus under section 26 has been talked about. So we are assuming that all the requirements have been complied. The requirement of section 39, minimum subscription and minimum application are also fulfilled. So can we say that it's a valid allotment of securities? So the answer is provisions of section 40 में आ रहा है एक चीज कि अगर आपने application करा है to 1 and more securities, then you should take the permission. It is very clear, not only the company has to apply for listing, but also take the permission from all the stock exchange. Since one of them has rejected the application and company has proceeded, it has violated section 40. Therefore, this shall deem to be an irregular allotment of securities. पेपर में ऐसे क्वेश्चंस पूछने हैं उसने आपसे. आप बोलोगे मैम ये तो याद हो गया, मिनिमम एप्लीकेशन, मिनिमम सब्सक्रिप्शन, ये तो सब समझ आ गया हमें, बट ये क्या पूछ रहा है क्वेश्चन? सेक्शन 40 मैंने अभी आपको बुक में से क्यों पढ़ाया? दोबारा बताने के लिए. Applied to 1 or more recognized stock exchange and obtained the permission. You came to NSE. NSE said no. BSE said yes. किसी ने नो कहा है तो किसी वजह से कहा होगा ना. आप फिर भी जाकर सिक्योरिटीज लिस्ट करा रहे हो. आपने परमिशन सिर्फ BSE से ली, आपको यस हो गया, कोई प्रॉब्लम नहीं. आप 2 जगह गए, NSE एंड BSE, एक जगह से रिजेक्ट हो गया, अब प्रॉब्लमैटिक वाली बात है. अब आपने वायलेट कर दिया. किसी को सेक्शन को वायलेट करोगे? सेक्शन 23 को वायलेट करोगे. अगर प्राइवेट कंपनी हो तो प्रोस्पेक्टस इशू कर रहे हो, बिल्कुल गलत बात. पब्लिक कंपनी हो और प्रोस्पेक्टस इशू करे बिना ही सिक्योरिटीज लिस्ट कर दी. आपको लिखवाऊं मैं सारे इरेगुलर अलॉटमेंट के केसेस. नंबर 1, सेक्शन 23, यू allotted securities without issue of prospectus. क्या कर दिया? इरेगुलर अलॉटमेंट वॉइड है. गलत है ना? सेक्शन 26 में तो बहुत सारी गलती है. फाइल ही नहीं करा, डिक्लेरेशन नहीं लिया, स्टेटमेंट्स नहीं है, एक्सपर्ट का कंसेंट नहीं है, कुछ भी गलती कर दी तो वॉइड है सेक्शन 26 वाला सारा. फिर सेक्शन 39 में मिनिमम सब्सक्रिप्शन नहीं आया, मिनिमम एप्लीकेशन नहीं आया, चेक में नहीं आया, कैश में आ गया, गलत है. अलॉट कर दिया तो void है. फोर्थ में सेक्शन 40 में परमिशन फ्रॉम स्टॉक एक्सचेंज कंपल्सरी है. रिजेक्ट हो गया कहीं से परमिशन, फिर भी आपने अलॉट कर दिया तो वाइड. सेक्शन 23, 26, सेक्शन 29, 40 में मैंने कहा था एप्लीकेशन देखनी है कि अलॉटमेंट ऑफ सिक्योरिटीज वाइड तो नहीं है. Everybody write down these points. Clear everyone? Regarding rejection, Anil, very good. Very good. Chavan, you have also given the correct answer. Prajapati, good. Therefore, the company should refund the money. Yes, Priyanshi, it will be taking place, so don't worry. Pooja B, your answer is correct. पॉइंट 4 एक बार और मैम प्लीज. अनुभव मलिक, क्या नहीं समझ आया? पॉइंट 4 वो बोलते हैं कि अपने स्टॉक एक्सचेंज से परमिशन लेनी. आप 2-3 स्टॉक एक्सचेंज के पास गए, उन्होंने आपको एक ने मना कर दिया, तो फिर परमिशन अगर आप लेने गए हो तो सबसे परमिशन मिलनी चाहिए, ये कंपल्सरी. इट इज वेरी क्लियर दैट ऑल ऑफ देम शुड गिव यू परमिशन. साहिल कुमार, सतीश, ऑल योर आंसर्स आर करेक्ट बेटा. मुस्तफा, yes, Mustafa, you can write down as per the provisions of Companies Act. That is also fine. Sections are not compulsory. Very good, Satish. For that forfeit, answer is correct. So, Anubhav, there might be, it has to be a recognized stock exchange. So, if there are more than 2-3 recognized stock exchange, then he can definitely do. Okay. See, it says it is very clear that not only the company should apply for the listing, but also obtain the permission from their before making the public offer. Since one of the 3 stock exchange where the company has applied has rejected and company still proceeded, they have violated the provisions of section 40. क्योंकि लॉ क्या कहता है? मेक एन एप्लीकेशन टू वन और मोर रिकॉग्नाइज्ड स्टॉक एक्सचेंज और एक्सचेंजेस एंड ऑब्टेन द परमिशन फॉर द सिक्योरिटीज टू. अगर आपने अप्लाई करे तो आपको परमिशन मिलनी चाहिए. आप अप्लाई ही मत करो, आप एक को ही अप्लाई करो एंड वहां से परमिशन ले लो, प्रॉब्लम ही नहीं आएगी. ठीक है, सबको समझ आ गया? इंपॉर्टेंट क्वेश्चन था बेटा ये. अच्छा, अब अंडरराइटिंग कमीशन के ऊपर आ रहा है. एक और कर लेते हैं. Section 40 requires every company shall make an application to one or more recognized stock exchange before making public offer. Madhav has filed an application to 3 stock exchange for securities to be dealt and received the permission from couple of them and proceed. Will there be a penalty ranging from 5 to 50 lakhs or no penalty, or it shall be ranging from 5 to 50 lakhs and for the officer for 50,000 and imprisonment, or it is 5 to 50 lakhs and 50,000 to 3 lakhs? जल्दी बताओ मुझे क्या आंसर है. कोई पेनल्टी लगेगी और लगेगी तो कौन सा? A, B, C, D, which is correct? Anubhav Malik, now you can answer this one. I think B is correct. Mustafa, ऐसे नहीं, पहले पढ़ो ध्यान से. Yes, Mustafa, if you write wrong section, it gives a very bad impression. Better don't write the section. Yes, Harsh, that's correct. Answer me for this one now. Jaya Manocha, excellent. Shamli, good. Pooja B, गलत आंसर है. प्रजापति, करेक्ट. ध्यान से पढ़िए क्वेश्चन को. जूली कुमारी ने ठीक दिया है, चवन ने ठीक दिया है आंसर. Fatima, good. Anybody else who's left? Sabya, very good. Everybody has given the correct answer. So C is the correct answer. अभी हमने करा कि अगर आप स्टॉक एक्सचेंज पे जाते हैं, सबसे अगर आपको परमिशन नहीं मिलती है तो आपको पेनल्टी लगेगी, बिकॉज द परमिशन शुड बी रिसीव फ्रॉम ऑल स्टॉक एक्सचेंज वेयर द रिक्वेस्ट हैज बीन सेंड. साइड पे लिख के रख लो अपने बुक में ये पॉइंट. Write down under section 40 subsection 3 in your module. Permission should be received from all the stock exchange to which we have applied. Clear? Which of the following statement is contrary? नहीं, private placement नहीं करा. Private placement नहीं है सर. चलो अंडरराइटिंग कमीशन कंप्लीट करते. अंडरराइटर कौन होता है बेटा? A company may pay commission to anybody subject to the rules 13 of the Companies Prospectus Act. Underwriter, somebody who wants to buy a company's shares if not fully subscribed by the public. Underwriters are the brokers who have given a guarantee to the company that, look, ABC Limited, if you are coming up with 1 lakh shares, I give you the guarantee that whole of your 1 lakh shares will be taken up by the public. Now, suppose only 70,000 shares were taken up by the public. So, since they have given the guarantee of 1 lakh, underwriters will take up these 30,000 shares. So, if not fully subscribed, they buy the company's shares. And for this work, they may demand commission from the company for this protection that they have given to the company. So, they're trying to protect the company. Company risk ले रही है, 1 लाख shares लेकर आ रही है public में. हो सकता है subscribe हो सकता है ना हो. तो उसने कहा, कंपनी ने कहा, मैंने क्यों हेडेक लेनी है, मैं अंडरराइटर अपॉइंट करती हूँ. अंडरराइटर अपने आप सिरदर्दी लेगा एंड मेरे सारे शेयर्स वो सब्सक्राइब करवा. अगर वो नहीं करवा पाता तो बैलेंस शेयर्स अंडरराइटर विल टेक. Is that clear? So for this work protection that the underwriter is giving to the company, he will be charging certain commission. So underwriter is working as an agent, and when agent is working on behalf of the company, we pay commission to them. This commission will be paid only if it is authorized by articles of association. So payment of commission कैसे होगा? एक तो articles में authorization होनी चाहिए, and it will be paid out of the proceeds of the issue. ये 70,000 जो shares public ने लिए हैं, whenever we receive the amount for these 70,000 shares, suppose they were for 100 rupees, so we have received 7 lakh rupees. Now out of that 7 lakh, we can pay the commission or the profits of the company or both. Number 1, articles authorize करेंगे, and फिर हम issue वाला जो proceeds जो हमें पैसा मिला है public से उसमें से या फिर कंपनी के प्रॉफिट्स में से या दोनों में से हम कमीशन को पे कर सकते. ऑथराइजेशन क्या होगा एंड सोर्स क्या होगा. थर्ड पॉइंट, कमीशन का रेट क्या हो. अगर तो शेयर्स सेल कर रहा है अंडरराइटर, इफ द अंडरराइटर इज सेलिंग द शेयर्स इन द मार्केट, देन 5% ऑफ द प्राइस एट व्हिच द शेयर्स आर इशूड और द रेट टोल्ड बाय आर्टिकल्स व्हिचएवर इज लेस. So my dear students, if the rate is 5% of the issue price of shares, जिस प्राइस पे हमने शेयर्स को इशू करा है उसका 5% और आर्टिकल्स में लिखा है 3%, तो कितना देंगे? एनी लेस रेट टोल्ड बाय आर्टिकल. सो आर्टिकल ने कम बताया है तो 3%. ठीक है, सभी लोग एग्री करते हैं 3%? गुड. Yes, who undertake to purchase the securities if they go unsubscribed. Absolutely correct. They are the underwriters. If it is written 13% in the articles, then how much commission can be paid to the underwriters? 5% or 13% on the shares? Savya, Mustafa, very good. Shamli, Anubhav, Julie, Jaya, 5%, because minimum amount is 5%, whichever is less. ऐसे आप फातिमा, गीता, प्रजापति, सबने सही आंसर दिया. वंडरफुल. एंड अगर मैंने सिक्योरिटीज में डिबेंचर्स इशू करे हैं और अंडरराइटर्स ने मेरी डिबेंचर्स इशू कराने में हेल्प करी है, तब कितना कमीशन देंगे? 2.5% ऑफ द डिबेंचर प्राइस और whichever rate is less than the articles. So अगर लिखा है 2.5% commission will be given on debentures or 1.5% is written in the articles, then how much commission will you be paying for debentures? Very good, Savya, Fatima, Chavan, Ria. Very good. No, Ria, not 2.5%. Articles में 1.5 लिखा है तो 1.5. जो भी कम बताए. एंड अगर आर्टिकल्स में लिखा है 11.5 फॉर डिबेंचर्स एंड 2.5, फिर कितना देंगे हम? फिर हम 2.5 देंगे. गुड. Understood, everybody? So underwriters are the people who are agreed to buy the shares if they're not fully subscribed, and they will be paid the commission 5% of the issue price of shares, 2.5% of the debentures, or whatever is less in the articles. Authorization in the articles has to be given out of the proceeds of the issue or profits of the company. Both can be used for paying the commission. So the maximum rate of commission can be 5% and 2.5%, subject to the rate authorized by the articles. Fourth point वो कहते हैं prospectus will also disclose the name of the underwriters, the rate and amount of commission payable, and number of securities which are underwritten or subscribed by the underwriters. Fifth point वो कहते हैं ये जो contract बनाया हमने underwriters के साथ commission का, it shall also be delivered to the registrar along with the prospectus for the file. जब prospectus file करते हो साथ ही ये underwriter का contract भी file कर लो. याद हो गया सबको? Prospectus में क्या क्या लिखना है? Name of the underwriters, rate and amount of commission paid, and number of securities subscribed, and this shall also be filed with the registrar. Everybody is clear? Now we're going to do a question on section 40, commission. Kapoor Builders decides to pay 2.5% of the value of debentures underwriter commission to the underwriters, but the article authorized only 2%. Company decides to pay the underwriter in the form of flats. Examine the validity. कहते हैं हम flat दे रहे हैं उसको, other than cash kind दे. So section 40 subsection 6 कहता है कि payment of connection of commission can be given as per the rules and Act of Companies Prospectus Allotment Security Rules. We can give. However, the commission shall be authorized by the articles, and out of the proceeds of the issue or profit shall be given. The rate shall not exceed 5% of the issue of shares, and in case of debentures 2.5%, or less articles, whatever is specified in the articles of association. In this case, we are trying to give underwriting commission is limited to 5% of the issue price in case of shares and 2.5% in the debentures. But Kapoor Limited is paying underwriting exceeding 2%, which is invalid. Company may pay in the form of flats because it does not impose any restriction through the source, though the source has been told, but it does not put any restrictions. वो कहते हैं हमने अंडरराइटर को फ्लैट्स दे दिए, घर दे दिए, कमीशन के बदले में घर दे दिए. कहीं पे ऐसा लिखा है सेक्शन 40 में कि आप काइंड में नहीं दे सकते, कैश कंपलसरी, ऐसा तो नहीं लिखा. तो कहते हैं नंबर 1 पॉइंट आप दे सकते हो बिकॉज रिस्ट्रिक्शन नहीं है. नंबर 2 पॉइंट 2% से ज्यादा एक्सीड नहीं करना. आप 2.5% दे रहे हो तो वो गलत है. अगर आर्टिकल्स में 2% लिखा है तो आप बच्चा 2% ही दो. रिवाइज करना है आज सारा कुछ घर जाके, बिकॉज हम चैप्टर कंप्लीट कर रहे हैं, 2 सेक्शंस और पढ़े हैं, तो मैं समझाऊंगी सब, बट रिविजन ना करें तो भूल जाओ. अब आ जाते हैं सेक्शन 41, वेरी वेरी इंटरेस्टिंग सेक्शन एंड वेरी वेरी सिंपल. 5 मिनट में आपको समझ आ जाएगा, जो कि इतनी कॉम्प्लिकेटेड टर्म्स. ग्लोबल डिपॉजिटरी रिसीट सेक्शन 41 tells us about how we can raise the money abroad. Company needs to raise the depository receipts abroad. If I am a company, Reliance, and I want to trade my shares in Canada or USA or New York or anywhere in UK. So if I'm doing it in America, then it is American depository receipts. Apart from America, any other receipts that I use is global depository receipts. So let's take the example of UK. Reliance wants to raise its securities, raise the money from foreign investors, and they want to list their securities on UK stock exchange. So company needs to find a domestic custodian bank, which will further give the shares to the overseas depository bank so that the depository receipts can be issued abroad. मैम ये आपको तो आता है, हमें क्या पता कौन है कस्टोडियन बैंक, कौन है ओवरसीज, क्या बातें कर रहे हो आप, हमें तो समझ ही नहीं आया. So let's make it a little simpler for all of you. This is India, this is overseas UK, सिंगापुर कहीं पे भी. So एक इंडियन कंपनी है रिलायंस, इक्विटी शेयर्स इशू करेगी और एसबीआई के पास चलेगी, डोमेस्टिक कस्टोडियन बैंक के पास गई और कहती है कि मेरे शेयर्स खरीद. इंडियन कंपनी रिलायंस वेंट टू डोमेस्टिक कस्टोडियन बैंक, जो आपकी कंट्री का बैंक है उसे कहते हैं डोमेस्टिक कस्टोडियन बैंक. जो बाहर की कंट्री का बैंक है उसे कहते हैं ओवरसीज डिपॉजिटरी बैंक. हियर वी यूज द वर्ड शेयर्स, हियर वी यूज द वर्ड डिपॉजिटरी रिसीट्स. So Indian company will go to the custodian bank, say for example SBI, and they will sell their equity shares to them. कहते हैं 9 लाख equity shares है, आप खरीद लो मुझसे एंड मेरी बाहर शेयर्स ये वाले रेज करवाओ. अब ये एसबीआई का काउंटर पार्ट होगा यूके में, कहीं भी ओवरसीज में, तो वही उसको बोलेगा कि सुन भाई मेरे पास 9 लाख इक्विटी शेयर्स आ गए हैं, तो अब्रॉड में ओवरसीज इन्वेस्टर्स को डिपॉजिटरी रिसीट्स अब इशू कर सकता है. सो इंडियन कंपनी बनाएगी ओवरसीज के साथ डिपॉजिटरी एग्रीमेंट एंड इंडियन बैंक बनाएगा कस्टोडियन एग्रीमेंट. 2 तरह की एग्रीमेंट्स बनेगी हमारे बाहर वाले बैंक के साथ. डिपॉजिटरी एग्रीमेंट दैट वी आर गोइंग टू डिपॉजिट आवर शेयर्स विद यू, एंड कस्टोडियन एग्रीमेंट दैट नाउ द शेयर्स दैट वर इन माय कस्टडी, नाउ यू आर होल्डिंग देम इन योर कस्टडी. And once the overseas depository will receive the shares in their custody, physical shares नहीं जाएंगे, वो उसे बता देगा कि मेरे पास शेयर्स आ गए. अब एक एंट्री हो गई, कस्टोडियन एग्रीमेंट बन गए. They will issue depository receipts in abroad. So when depository receipt is issued to Mr. John in UK, so it will be said that he is holding a share of Reliance. Foreign investment in Indian company is the meaning of global depository receipts, process of getting the depository receipts abroad. समझ आया सबको? Manner and issue of receipts. A company may issue depository receipts after passing a special resolution. So company को कभी भी depository receipts issue करने हैं तो special resolution pass करेगी. It may be issued by the public offering or private placement or any other manner. The depository receipts against the issue of new shares or may be sponsored against the shares according to CG or Reserve Bank of India. So central government या RBI बताएगा क्या rules लगेंगे for issuing these new shares. And once these shares have been allotted to the overseas depository bank, depository receipts will be issued. जो मैंने आपको हिंदी में कहानी समझाई वो आपके सामने इंग्लिश में लिखी हुई है. Once again, I am going to repeat in English as well as in Hindi. A company will issue the deposit receipts in foreign country. They will have to pass SR in the meeting. For passing how these depository receipts will be issued, we will first take the permission of central government and RBI. The company will give their shares to the custodian local bank over here. This bank will give their shares to the overseas depository bank. Once the overseas depository has signed the custodian agreement, they will issue the depository receipts to the foreign investors. Understood? And what are the voting rights? The depository receipt will now, Mr. John को मैंने दिए थे shares. So this depository receipt holder will now become member of my company. So now Mr. John is member of Reliance, and he is also entitled to vote on the conversion of depository receipts into underlying shares after following the procedure. So overseas depositories will vote on behalf of the holders under the agreement that they have entered. So if I have allotted one share over here, see for example, 10 shares are issued in lieu of one depository receipt. कहते हैं यहाँ पे जब 10 शेयर्स इशू होंगे तो उसके बदले में एक डिपॉजिटरी रिसीट इशू होगी बाहर. सो अगर 10 शेयर्स के 10 वोटिंग राइट्स हैं तो एक डिपॉजिटरी रिसीट विल आल्सो गेट 10 वोटिंग राइट्स. So simply it says depository holder will become member of the company and he will get as many voting rights as the shareholder is entitled to receive in India. Clear? एक बार मॉड्यूल में से भी देख लेते हैं, फिर हमारा सिर्फ प्राइवेट प्लेसमेंट रह जाएगा. No commission shall be paid to the underwriter which are not offered to the public for subscription. So commission सिर्फ तभी दोगे अगर वो हमारे शेयर सब्सक्राइब कराने में हेल्प कर. So अगर उसने 70,000 शेयर सब्सक्राइब कराए तो 70,000 के ऊपर कमीशन मिलेगी उसे. ये सारा हमने कर लिया है. मैक्सिमम रेट भी हमने देख लिया है. In Swift Pharma Labs issued the shares. It is authorized the rate of 2%, since the commission should not exceed 5%, and the less hence the cap limit is 2%. बिल्कुल ठीक है ये. Board of Director decide to pay 5% of the issue price on underwriting commission. However, articles permit only 3%. तो कितना दोगे? सिर्फ 3%. Can they pay the proceeds out of the commission out of the proceeds? It is valid. GDRs में सिर्फ बच्चा आपने ये टेबल याद करना है और जो मैंने आपको कहानी सुनाई है वो याद करनी है. वोटिंग राइट्स का भी हमने कवर कर लिया. CG RBI से परमिशन लेनी है. अंडरलाइंग शेयर्स allotted in the name of depository receipts will be issued and all these points. Now we are depository agreement क्या होता है? अनुभव मलिक, हमने बिल्कुल नहीं देखना कस्टोडियन एग्रीमेंट क्या होता है, डिपॉजिटरी एग्रीमेंट क्या होता है, बिल्कुल नहीं देखना. सिर्फ ये समझना है कि हमारी कंपनी ने डिपॉजिटरी एग्रीमेंट करा बाहर वाले बैंक के साथ और हमारे बैंक ने कस्टोडियन एग्रीमेंट करा. डिपॉजिटरी एग्रीमेंट एक ऐसा एग्रीमेंट है जिसके थ्रू आपकी इंटरेक्शन हो रही है ना, किसी कॉन्ट्रैक्ट या एग्रीमेंट के थ्रू ही होगा. ऑलराइट, let's take a small. Who says I didn't get this part? What have you not understood? Raise your hands. Anyone have any doubt? First raise your hands, then only I'll take a point. Anyone having any doubt still here, please feel free to raise your hands. जिसको नहीं समझ आया. Yes, Shravan, this is not very relevant. That's why we just do it in a very simple way. What is relevant and important is private placement, which I am going to do with you right now. And so many questions also coming. So shall we take a 5-minute small break so that you can just freshen up, because we have another important topic coming up. Anyone having any doubts, please raise your hands. Indrani, good answers for the previous. कोई किसने लिखा था? Mustafa, GDRs, I hope you have understood now. It's not that relevant because now it's very, very easy to issue the securities abroad. It's just part of your syllabus, so you have to do. Yes, Anil, you cannot value that. Okay. Yes, Anubhav, only for the notified companies. That's correct. Section 25 is specifically for your deeming provision, that the document that you're using, that is a deemed prospectus. Okay. Here we are paying the underwriting commission. That is a separate thing. Yes, Anil.
Ma'am, in case of GDRs, like if we directly invest in foreign companies,
foreign company में invest करें.
What's the difference? Hello, ma'am, I'm audible.
Yes. Amar, you will get the notes on the portal. Don't worry. All these notes will be uploaded. Hanji, beta. Yes, Anil. All right, let's.
Without involvement of SEBI, can a company directly contact overseas depository?
Was there any issue about SEBI?
Is it possible?
Was there any mention about SEBI when I taught you section 41? Tell me. Tell me.
No,
एक बारी फिर-
not CP. Sorry, SBI. Like without custodian.
एसआर
Fine.
पास करो चुपचाप अपनी जनरल मीटिंग में कंपनी के लिए और सीजी से अप्रूवल ले लो सेंट्रल गवर्नमेंट से एंड रिजर्व बैंक ऑफ इंडिया, उन दोनों का रोल है, नथिंग मोर देन दैट. ओके एंड जितना मैंने बताया
Okay, even without SBI involvement, it is possible, right?
yes it is. कुलदीप नगर एब्सोल्युटली करेक्ट.
Okay, ma'am. Thank you.
4 yes. सेक्शन 24 में अभी आपको दिखाती हूँ जहाँ पे हमने लिखा हुआ है इट प्रोवाइड्स एग्जेम्पशन फ्रॉम द जीडीआरस. हमने फर्स्ट डे करा था. I'll take a small break. Just read section 24, subsection 3 and 4 meanwhile. Sabhi taking small 5 minutes break here. All right, students, I hope you have read section 24, subsection 3 and 4. And now your doubts will be clarified for GDRs also. But still, again, we have done in detail about GDRs also. Now moving to the last topic of today's class and chapter prospectus, because we have been doing revision along with that everything. So everything is complete except yes, Kuldeep, that's absolutely correct. Except section 42. Now all the eyes, ears and full attention over here, and we are going to float in the last part of the chapter, that is section 42, private placement. Till now, we were studying section 23 to section 41, totally engrossed in the public company, how it is raising the prospectus, how it is issuing, how it is raising money. We also understood how the allotments are irregular if you're not following section 23, 26, 39, and 40. But now we will be going through a private placement, because a private company also at times need money. So how they are going to raise the money? They will invite the issue of securities to a selected group of persons. It is not by the way of public offer, but through a private placement, offer cum application. PPOCA form is used. There we were using different forms. We were issuing prospectus. A private company, say for example, ABC Private Limited, it cannot issue a prospectus, but it can raise its money by doing a private placement under section 42 and rule 14. So how we try to remember rule 14? 14 3s are 42. So section 42 hai and rule 14. ठीक है ना? This is just a hint I've given you, because we are not doing so many sections, but private placement का तो एक ही section है. तो हम section 42 and rule 14 याद कर सकते हैं. कैसे याद करना है? 14 का 3 times करा तो section 42 and rule 14 याद रहेगा. So number 1, here we are making an offer to a limited group of people through private placement, offer cum application. What conditions are to be satisfied? The offer shall not be made to more than 200 persons in a financial year, and SR needs to be passed. So पहली बात तो वो बोलता है कि SR पास करना है, and 200 लोगों से ज्यादा नहीं होने चाहिए ना फाइनेंशियल ईयर. मतलब 2003 में मैंने करा तो 200 persons, 2004 में फिर से कर सकती हूँ 200 persons. एंड ये जो 200 persons है, ये पर सिक्योरिटी, 200 for preference shares, 200 per person for equity shares, 200 for debentures. In a financial year, per security, 200 persons के पास में ऑफर लेकर जा सकती हूँ कि प्लीज आप मेरे शेयर्स को सब्सक्राइब करो. मैक्सिमम लिमिट कितनी है? 200. क्या लेकर जाना है? PPOCA फॉर्म. PPOCA प्राइवेट प्लेसमेंट, PP प्राइवेट प्लेसमेंट, OCA ऑफर कम एप्लीकेशन. प्राइवेट प्लेसमेंट ऑफर कम एप्लीकेशन लेटर उनके पास लेकर जानी है कि आप मेरी कंपनी में शेयर्स खरीद लीजिए, एंड इसके लिए मैंने SR पास कर. This selected group of people are also known as identified persons. While counting the limit of 200, these are not included. Qualified institutional buyers, जिसको हम कहते हैं QIBs. QIBs कौन होते हैं बच्चे? जो बड़े बड़े buyers है, having the financial assets of more than 100 crores. So they are not included in the limit of 200. Section 42 कहते हैं इनके पास जा सकते, कोई प्रॉब्लम नहीं, इनको 200 में नहीं गिनेंगे. And ESOPs while you're issuing, section 62 subsection 1 clause B, share capital and debentures. आपने employees को ESOPs दिए, employee stock options दिए. That is not included under 200. So say for example, ABC Private Limited raises its issue securities to 200 specified buyers, 200 QIBs, and 250 ESOPs they have issued. Is it within the limit? Yes, ma'am, it is absolutely within the limit, because this 150 will not be counted in the limit of 2. Is that correct? Qualified institutional buyers are defined by SEBI. हमने लर्न करना नहीं मैम, हमने बस SEBI बता रहे हैं हमें क्या लेना. SEBI थोड़ा ना, हम SEBI ऐप नहीं ना पढ़ रहे हैं. कहाँ पता है इनके बारे में? SEBI बताए. SEBI को पूछ लेना दे आर डिफाइंड बाय सिक्योरिटीज एंड एक्सचेंज। हमारे लिए क्या बड़े बड़े बायर्स हैं जो फाइनेंशियल एसेट्स 100 करोड़ से ज्यादा। एंड लिमिट ऑफ 200 किसके लिए है मैम? एवरी इक्विटी शेयर, एवरी प्रेफरेंस शेयर और डिबेंचर्स। मेरे एक साल में रेस करने इक्विटी शेयर्स भी, प्रेफरेंस भी, डिबेंचर्स भी, प्राइवेट कंपनी ना 600 लोगों को लिमिट बन जाएगी। 200 200 200 QIBs को भेज दो, 200 QIBs भी भेज दिए कोई बात नहीं, भेज दो 400 भेज दो, 100 ESOPs भी कर दिए कोई बात नहीं, भेज दो, वो 200 के लिमिट पे नहीं है। अब प्रॉब्लम कहाँ आएगी? एक्सेप्शन के अंदर एक्सेप्शन। सो पहली बात कहते हैं फॉर काउंटिंग 200 लिमिट QIBs एंड ESOPs आर नॉट इंक्लूडेड। बट इफ यू आर NBFCs, National Banking Finance Corporations, or HFCs, Housing Finance Corporations, then these are included in the limit of 200. ये क्या बात बनी मैम? अभी तो बोला नॉट इंक्लूडेड, बट अगर NBFC कंपनी है और वो पीपो का फॉर्म इश्यू करती है 150 इन्वेस्टर्स को एंड 200 क्वालिफाइड institutional buyers को, then it is not done, because here only 50 QIBs can be taken because they are included in the limit of 2. If you are an NBFC or you are HFC, then these two exceptions are included. Otherwise, QIBs and ESOPs are not. And this limit of 200 is for each financial. यहां तक सबको समझ आ गया जो मैंने बोला है? Everybody has understood what I said? Yes, non-banking finance corporation, Mustafa, absolutely correct. उनके लिमिट के लिए QIBs included. Yes, yes, privately it is placed to private. Private and confidential भी लिखा होगा ना, बिल्कुल correct. Yes, yes, अनुभव, section 23 subsection 3 बिल्कुल ठीक कह रहे हो। एक बार ही दिखा भी दूंगी, एंड में रिमाइंड कराना, ओके? Okay, thank you, Satish, for saying that it's clear and understood. Shall we move forward? Okay. Anubhav Mishra, Prajapati. Good. Okay, Sabu. So what is the process? I've simplified for you all. First of all, pass a board resolution. ABC Private Limited बैठेगी और बोर्ड से रेजोल्यूशन पास कराएगी कि बोर्ड हमें पैसा चाहिए, क्या हम प्राइवेट प्लेसमेंट कर दें? Board has to authorize it. Board of directors will sit and have a meeting. What is the meaning of board meetings? What is the meaning of general meeting? MGT chapter number 7. There I will explain you what are these things. But first, a board resolution has to be passed. Name of 200 selected people will be decided in this board. And PPOCA letter will be sent within 30 days of selection. So first 3 points are related to board resolution. We will pass the board resolution. We will decide the name of 200 people. 200 में QIBs and ESOPs are not included. And within 30 days of the selection, we will send them the PPOCA letter. Then what will happen after sending the letter? Ma'am, we'll pass the SR. Notice of SR will be included in the explanatory statement. अब explanatory statement क्या होता है? Chapter 7. Section 102 में पढ़ेंगे क्या होता है? एक्सप्लेनेटरी स्टेटमेंट। जब भी कोई कंपनी मीटिंग करती है, नोटिस भेजती है, तो एक डिटेल्ड स्टेटमेंट भेजती है, उसके साथ ये नोटिस ऑफ एसआर लगा देना, सिर्फ इतनी सी बात, containing all the details. So SR will be passed. SR will go along with the notice, along with explanatory statement, and no SR is required if non-convertible debentures are issued within the limit of 180 subsection 1 subsection C. So children, section 180 सबसेक्शन 1 सबसेक्शन सी फिर से आपका शेयर कैपिटल का पार्ट है, घबराना नहीं है, ये सारी चीजें रिपीट होंगी। क्या लिमिट होती है सेक्शन 180 सबसेक्शन 1 सबसेक्शन सी की? 100% ऑफ द पेड अप शेयर कैपिटल प्लस फ्री रिजर्व्स प्लस सिक्योरिटी प्रीमियम अकाउंट। पेड अप शेयर कैपिटल प्लस फ्री रिजर्व्स प्लस सिक्योरिटी प्रीमियम अकाउंट। इफ यू आर बोरोइंग विद इन दिस लिमिट and issuing non-convertible debentures, then SR is not required. बस इतनी सी बात। 180 सबसेक्शन 1 सबसेक्शन सी की लिमिट में अगर आप हो तो SR नहीं पास करना। तो मैम ये तीनों पॉइंट्स तो SR से रिलेटेड है। पहले 3 पॉइंट BR पास करो, 200 नंबर डिसाइड करो, 30 डेज में सेंड दी एप्लीकेशन PPOCA लेटर। 3 points, SR to be passed, notice of SR has to be sent, no SR if it is within the limit of 180 subsection 1 subsection C. Next point, money to be received. अब next point आपको सुने सुने लगेंगे, section 39 में जो पढ़ा है same basis से points. Money should be received by check or DD, not by cash. सेक्शन 39 में भी पढ़ा था एप्लीकेशन मनी कैसे रिसीव करनी, चेक से, कैश नहीं होना चाहिए, डिमांड ड्राफ्ट हो सकता है, चेक हो सकता है, सेपरेट बैंक अकाउंट में रखना है, सेक्शन 40 सब सेक्शन 3 में अभी पढ़ा सेपरेट बैंक अकाउंट. एप्लीकेशन मनी कैन बी यूज फॉर अलॉटमेंट विद इन 60 days ऑफ मनी रिसीव. हाउ मेनी डेज वी वर टेकिंग इन सेक्शन 39? सेक्शन 39 में कितने दिनों में हम पैसे लॉट कर रहे थे? वेरी गुड साव्या, 30 days. एक्सीलेंट एवरीबडी. अनुभव, अनिल, 30 days. ओके अनिल, व्हाट हैव यू नॉट अंडरस्टूड अबाउट एनबीएफसी एंड एचएफसी? अच्छा, इसके पॉइंट एक्सप्लेन करना, अभी कर दो, अभी कर दो. 30 days का आप समझ आ गया, पहले कंप्लीट करने दो एक बार, फिर डाउट्स लूंगी, ठीक है? 30 days, वेरी गुड शामली. बट यहाँ पे कितने दिन दे रहे हैं? 60 days में. आराम से कर लेना, प्राइवेट प्लेसमेंट है, एप्लीकेशन मनी है, 60 days में. हमें तो पता ही है कौन से 200 लोग हमने सिलेक्ट करे हैं, तो उनको 60 days में सिक्योरिटीज अलॉट. इफ नॉट अलॉटेड, क्या ये सेम है बच्चा? 15 days में ही रिटर्न करते थे, यहाँ पे भी मैम 15 days में रिटर्न करना है. वहां पब्लिक का पैसा था, 15% इंटरेस्ट दे रहे थे, यहाँ प्राइवेट है, 12% पर एनम पे इंटरेस्ट दे रहे. वहां कितने में देते थे? वहां 30 days में सिक्योरिटीज अलॉट करते थे, एंड अगर नहीं रिफंड करते थे तो 15% पर एनम में रिटर्न देते थे. यहाँ पे 12% पर एनम है. वहां पे रिटर्न कितने दिनों में फाइल करते थे? इतने सारी पब्लिक लोग इन्वॉल्व है तो 30 दिन लग जाते थे रिटर्न ऑफ अलॉटमेंट. यहाँ तो लिस्ट छोटी सी है, पता ही है, तो 15 days. अब अगर सेक्शन 39 याद है तो 30 days का 60 days हो गया, 15 days 15 days रहेगा, 15% का 12% हो गया, रिटर्न ऑफ अलॉटमेंट 30 days का हाफ हो गया 15 days. पहले वाले में डबल है, लास्ट वाले में हाफ है, 15 का 12%. Another method of learning private placement. अब बिफोर वी प्रोसीड अहेड, फटाफट से पहले रिवाइज करें. प्राइवेट प्लेसमेंट पीपीओ सीए फॉर्म चाहिए हमें, 200 से ज्यादा लोग नहीं होने चाहिए फाइनेंशियल ईयर में. मैंने कहा क्वालिफाइड इंस्टीट्यूशनल बायर्स एंड ईसॉप्स को नहीं ऐड करना. एग्जांपल क्या होगा? एबीसी प्राइवेट लिमिटेड गई, उसने कहा 150 इन्वेस्टर्स को मैंने पीपीओ सीए फॉर्म भेज दिया, प्लस 300 क्यूआईबीस को भेज दिया, प्लस मैंने 100 ईसॉप्स कर दिए. कैन वी से दैट द प्राइवेट प्लेसमेंट इज डन विद इन द लिमिट ऑफ 200? यस मैम और नो मैम? जल्दी बता दो. Yes, ma'am. Anubhav says yes. Shamli, everybody. Yes, ma'am. Why? Because it is within the limit of. But अगर यही, अनिल ध्यान से सुनो, वेरी गुड प्रेरणा, अगर यही एनबीएफसी इशू कर रहा हो तो क्या ये यस मैम ही रहता? अगर एनबीएफसी कर रहा होता तो 150 इन्वेस्टर्स होता, 300 क्यूआईबीज होता एंड 50 ईसॉप्स होता. नो, सिंपल, क्योंकि उसमें 200 तक ही लेना है, इससे ज्यादा नहीं जाना है. बाकी केसेस में क्यूआईबी ज्यादा भी हो सकते हैं, 200 से ऊपर भी हो सकते हैं. समझ आ गया एग्जाम्पल के साथ? सो बस यही था आपका प्राइवेट प्लेसमेंट में. क्वेश्चंस कर लेते हैं फटाफट से. Private company can make private placement. It has to pass SR. Minimum offer per person should have a market value of 20,000. Public company can make a private placement. Which of the statement is contrary? Public company तो कर सकती है और SR भी पास करना है, प्राइवेट कंपनी भी करती है. ऐसी कोई बात थी मार्केट वैल्यू ऑफ 20,000? बिल्कुल नहीं थी, तो ये गलत. Innovative Tech Solution wants to invite the subscriptions for 1.10 crores each on a private placement basis. The person identified are within the limit and include two other categories to which the statutory limit is not applicable. The categories are employees of the company who are offered ESOPs. What is the other excluded category? Quality institutional buyers, qualified institutional buyers, qualificational, qualified investing buyers. Jaldi in the chat box. Absolutely correct. B is the correct answer. So everybody has given the correct answer B. So देखो साथ के साथ याद हो गया ना. Next question करते हैं. Commission is permitted to be paid to any underwriter in respect of the securities where the securities are given on rights basis, bonus issue, private placement, or when the securities are given to public for subscription. When is the commission paid to the underwriters? A, B, C, D. Savya, wrong. Anil, correct. Anil, is this for this one or previous one? Anubhav Malik, absolutely correct. गोपाल गलत है. अच्छा पुराने वाले का है. Indrani, absolutely correct. Gopal, correct now. So D is the correct option, children. It's very simple. पब्लिक को देखो तभी तो अंडरराइटर्स आएगा. मैंने प्राइवेट प्लेसमेंट में कराया कुछ कमीशन का. सेक्शन 40 किसका था? पब्लिक कंपनी का. ओके ना. सो इट्स ऑलवेज फॉर द पब्लिक. Which of the statement is not true? In case of the shares, the rate of underwriting shall not exceed 5%. Underwriting commission should not be more than the rates, which is not true. Debentures shall not exceed 5%. Amount of commission shall be paid of profits. So out of profits तो होना चाहिए मैम. Shares का 5% से ज्यादा नहीं होना चाहिए. Underwriting commission should not be more than rates specified by articles. Debentures. क्या है इसका correct answer? A, B, C. Shamli Sharma, the first one to answer. Adil Khan. Mr. Chavan, Prerna, Jaya, Pooja, Julie Kumari, Fatima, Ria, everybody. Pooja B has given Vedant. Prajot, Santosh, Chetra, very good. Correct answers. Everybody is giving correct answers. That means they have paid full attention towards the lecture. So proud of you, students. C is the correct answer. एक और क्वेश्चन कर लेते हैं. Examine the validity of the rule. Articles contain that 4% of the issue price of shares can be paid as underwriting commission. Board of Directors decided to pay 5% of the underwriting commission. What will be the correct answer? Article says 4%. Board of Directors decided to pay 5%. तो कितना होना चाहिए? Yes, Shamli.
Ma'am, 4%.
Very good, because it cannot exceed the limit of articles. Excellent. Harsh Mishra, why don't you take a chance? Is it correct? Explain the cases of allotment as irregular. So this is the point that I was explaining you. I have written it down in your answer sheet also, that when company issues a prospectus, violate section 23, 26, 39, 40. तो ये सारे points मैंने आपके लिए लिख भी दिए हैं जो मैंने आपको क्लास में समझाए थे ना. ये सारे cases irregular allotment of securities के. A public company is planning to give a public issue and has appointed the underwriters for getting the shares. As a chartered accountant, tell what are the provisions. तो ये सीधा क्वेश्चन है अंडरराइटिंग कमीशन का. आप प्लीज देख लेना. एज इट इज लिखना है इसको. मैं जो आपके साथ करना चाहती थी वो था कॉम्प्लिकेटेड क्वेश्चन. कौन सा है? ये करेंगे. Prakash Limited want to raise funds for its upcoming projects. Accordingly, it has issued PPOCA letters to 55 persons, out of which 4 are QIBs and remaining are individuals. Before completing, it has sent another 155 persons in their individual names for the debentures. Equity shares के लिए करा, debentures के लिए करा. Being a public company, is it possible to issue securities under private placement? By doing so, company is in compliance with private placement. What if the offer of debentures is given for allotments, but within the same financial year? Tell me the answers. Absolutely correct answers given by everyone. Let's go through once the answers. First, you'll give the provisions of section 42. It should not be exceeding, the application for private placement should not be exceeding 50 or such higher amount. For counting the qualified institutional buyers, for counting the people, QIBs and ESOPs are not included. Maximum 200 can be made for each type of security. ये सारा आप उसका लॉ में लिख दोगे एंड फाइनेंशियल ईयर भी हो सकता है. एवरी फाइनेंशियल ईयर में 200 की लिमिट. व्हाट इज द एनालिसिस? पब्लिक कंपनी जा सकती है प्राइवेट प्लेसमेंट के लिए? यस एब्सोल्युटली मैम. पब्लिक कंपनी को मना थोड़ी ना करे. प्रोहिबिटेड नहीं है पब्लिक कंपनी के लिए, प्राइवेट कंपनी को प्रोहिबिटेड है पब्लिक प्रोस्पेक्टस के. So company has given offer to 55, out of which 4 are qualified, so 51% are within the limit. Company complies with the private placement rules. Another, it is making before allotting the security the first offer. As per the question, company has given another private placement for debentures. So there can be only one private placement in a year. Before completing, you cannot give the second offer. Once you have to complete the first offer, then you can proceed. Offers given will be treated as public offers. So अगर आपने साथ ही दे दिया, 51 को दिया आपने, 51 को दिया एंड साथ ही आपने 155 और कर दिया, तो लिमिट एक्सीड होगी ना आपकी. 6 हो गया यहाँ पे एंड 10 एंड 206, तो लिमिट एक्सीड कर गई. So it shall deem to be a public offer. In case the offer for debenture is made in the same financial year after allotment of equity shares, then both can be treated as private. तो क्या कहने की कोशिश कर रहे हैं? अगर आप सेम साल में बिना कंप्लीट करे इशू करते हो तो प्रॉब्लमेटिक है, बट अगर आपने कंप्लीट कर लिया है एंड फिर आप इशू करते हो देन इट्स फाइन. इज इट ओके? डोंट वरी. ऑन मंडे अगेन आई एम मीटिंग यू फॉर शेयर कैपिटल एंड डिबेंचर्स. Revise your chapter prospectus nicely. Go through private placement. We will first revise private placement, then we will proceed for the share capital and debentures, the new chapter. Is that okay with you? So all the best. Keep studying. I hope no doubts. Anybody wants to ask anything, you can raise your hands. Otherwise, I'll see you on Monday. Thank you, Shamli. Thank you. I'm glad you've understood everything. Okay. Thank you, Savya. Anubhav, we will go through those points. Don't worry. If you want, I'll just make you see right now. Anubhav says, ma'am, section 23, subsection 3, एक बारी बता दो. चलो बता देते हैं. फिर क्योंकि हम सिर्फ प्राइवेट प्लेसमेंट ही करेंगे उस दिन, और नहीं कुछ करेंगे, बिकॉज वी स्टार्टिंग विद शेयर्स. सो ये रहा बेटा. तो साफ कहता है आपको कि इनडायरेक्ट लिस्टिंग डोमेस्टिक कंपनी अब स्टॉक एक्सचेंज पे कर सकती है विदाउट एनी इंटरमीडियरीज. सो GDRs in the foreign market. So direct listing exclude intermediaries, decreasing the overall cost. मैंने आपको पहले भी बताया था. Section 23 subsection 4 has exempted the companies from complying with the provisions of GDRs and ADRs. Now it has become very, very simple. But since it is given as a part of a syllabus, we have to go through. Okay? All right. Thank you so much. Thank you, everyone. All right, sir, we are done. Thank you, Prajapati. Thank you, students. Yes, sir.